All right, we're in litigation class today, and we're going to talk a little bit about, it's basically session 11, chapter 12 in your book, request for production of documents under Rule 34 of the Rules of Civil Procedure or the Rules of Trial Procedure, Indiana Trial Rules. So basically, Rule 34 is involved with producing documents, tangible things, letting you inspect people's real estate, their house, things like that. Remember when we talk about ESI, electronically stored information, this would be one of the motions that you would file to ask for, let's say, all the emails associated with a case that could be saved, downloaded to some kind of a device like a jump drive or a CD or a DVD and provided to you as a response. So basically, request for production, very important. I mean, this is one of the biggest, most often used tools. And so again, we'd like you to respond with some answers. So basically, if you would just write up something that says that, what is Rule 34 and what are some of the things that can be included in it, and just hit on all the things that I've just touched on. Documents, what kind of documents could we be talking about? What about pay stubs? What about doctor bills? If it's a car wreck case, for example, somebody has lost wages, so you're going to need to see those pay stubs. If it's a divorce, someone's need to see the pay stubs in order to figure the child support. So there's a lot of reasons for production of documents in a lot of different kinds of cases. Here again, the old electronic stored information. This is something new that has burst on the scene. We never used to have it, but electronic stored information, like I said, more and more you're getting into sexual harassment, sexting, Facebook information, emails, a number of different things like that that can be produced as far as pictures, photographs, anything like that that's possible. And then the important thing too is permission for inspection of, like immovable objects, like for example, inside someone's home. Let's say someone's had a flood, they had flood insurance. You want to go in there, you represent the defendant, and you want to go in there and inspect that home to see just how much damage there is. You might want to have an expert go in there, take some pictures, look at it. Well, you have to have permission to go on the people's property. You can't just burst on the scene there without some kind of permission being worked out. So one of the important things on Rule 34 is that it also follows along with Rule 26B, and that is you need to serve the opposing party. Now, service is just by regular mail or by copy service on the opposing attorney. It's not certified mail. You don't have to send the sheriff out there. Once the lawsuit starts, as long as the parties send stuff back and forth, regular U.S. mail, then that is fine. I know the lawyers, if they're in the same county, they have a mailbox in the courthouse, and they just can put things in each other's mailbox, and that's considered service. And so basically, you need to be careful in the request for production to be detailed about just what it is you're asking for. Don't just, shotgun it, basically saying anything and everything. Try to get as detailed as possible. You might want to have a final comment in there that's and any other thing that could pertain to this case, something like that. So here again, Rule 34, production of documents. Give me some detailed information on your own for extra credit points on just what we mean by Rule 34. Another important aspect of this, in addition to the inspection, the pages for wages, doctor bills, anything like that, the cost of babysitting, a number of different things that could be documents in the case, is to also consider the use of the subpoena. and you can use a subpoena as a backup document. Usually a pretty good idea. So if you're looking for production of documents, we have a type of subpoena, and we call it ducis tecum, which is basically the Latin, and and it is basically produce documents or bring documents. The ducis is the documents, and tecum would be kind of probably a root that would be involved with take. So mainly what it's saying is take the documents like to the courthouse or to the opposing attorney or whatever. So that is another aspect of this to keep in mind, is that usually what you'll see is the request and request for production, and then you'll see pertaining to that also attached perhaps a subpoena ducis tecum. So subpoena means bring your body, and ducis tecum means bring the documents. So that's the difference. So time to respond on these is generally 30 days unless the court enters an order for a shorter time period. Each person is required to respond. Generally, you want to say in there that the request is continuing, meaning if there's any new developments, then they need to produce that as well. If you do have an objection, like we talked about earlier, some maybe older mental health records, something like that, you don't think that it has any bearing on the case, then you should file an objection within that 30-day period. And then look at Rule 29 also. You can enter into an agreement or stipulation about a different time. Maybe let's say you contact your attorney and you say, we need additional 30 days, so could we do this in 60 days? All that needs to be done though and worked out before the end of that first 30 days. Electronically stored information, again, it keeps cropping up. You may make an objection if it's information that has no real bearing on this case. May just want to embarrass somebody or drag the case out. And so some of this electronic material, like maybe pictures of a guy having an affair with another woman in a divorce, that has no bearing on the case because Indiana is a no-fault state. So why would you need pictures of somebody having an affair with another woman? And so, these are the kind of things, that can get you into trouble if you go too overboard with some of this. Also note that in Rule 45, request for production can be served on non-parties. Non-parties. Well, who's a non-party? It could be a person's doctor. Let's say it's a defendant's doctor. It could be the employer. It could be a number of different people that have some kind of relationship. What about a guy's accountant that's doing his taxes? Somebody like that would be a good candidate for a request for production. So, that's not very legible, is it? Gets down so far it's hard for me. So, the doctor, the employer, or the accountant are perfect examples. What about school? This has come up in divorces. Someone's trying to prove that the mother is an unfit mother for a custody case. And so you get school records. So the non-party could be, school records. The kid's passing, the kid's failing, whatever you want to try to establish, that the kid is doing well, the kid's not doing well. All this could be based upon school records. Johnny's acting out. His behavior is terrible. He comes, he's always tired. He's always dirty. Reports like that in a school report can be devastating in a custody case. And those things are available in those kind of circumstances. So important stuff here when you look at these rules. Remember that the rules have been in place for many years. and really goes back even as early as 46, even earlier, 1937. Some of this was based upon rules in England. And so request for production, very common, very important, and often used. And so would Rule 34, want you to make some comments about what Rule 34 is for some extra credit. Let me know if I can help you. As always, robdawalt@me.com. Thanks a lot. We'll be back with something else here very shortly.